Good night, Belizeans at home and abroad. My name is Leonard Brackett. Today is Friday. Uh, I'll be your chairman for tonight's program of the Belizean Affairs show, number 321. 321. As of right now, I don't see any one of my other colleagues in the background or the other panelists. And in the interest of time, I'll just go ahead. Uh, we're like 10 minutes, a little over 10 minutes behind schedule. So I'll just go ahead and start the program for tonight. We'll follow the same patterns as we normally do, which is I'll say a short prayer, after which I'll make a short reading, biblical reading. And if you permit me, I'll just bow my head for right now and proceed. Divine loving Father, once again we come before thy presence, asking that thou would continue to have mercy upon us, that thou would continue to look after us and our children and grandchildren, great grandchildren, those of us who have, and the rest of our extended family members, friends, and loved ones, wherever they are, as if they were each mentioned by name and number. Please bless our country of Belize, its people and leadership. Please bless this country of the United States, its people and leadership as well. And please bless the rest of humanity, especially those people who are in war zones and who are in tornado areas and hurricane areas and flooding and all kind of storm and disasters. Please be merciful unto them, loving Father, for we ask these mercies in Jesus' name. And please bless our program for tonight. Amen. Thank you very much for allowing me to indulge in that part of our program, that is to say a short prayer, and then I'll just pick a scripture now and do a little short reading. I'll take a reading from Job. I'm going to read, let's see, we'll read Job chapter, is this, yeah, Job chapter 34, and I'll start at verse 1. It says, "Furthermore, Elihu answered and said, Hear my words, O ye wise men, and give ear unto me, ye that have knowledge. For the ear tried words, as the mouth tasted meat." And that's my reading for tonight. I just went to that particular verse just now randomly. I didn't actually pick it per se, but in my estimation, I think it's going to rhyme or fall right in line with some of what I am hoping to convey tonight and deal with in tonight's message. And as you bear with me, you may become aware that that might be the case, because I know what I have set up in terms of what I'm hoping to present, but I didn't know that I would have picked. I opened the Bible just at random, and I passed. I went to Ezekiel. I went to Psalms, and then I feel I'll just go ahead and read something from Job. I know the book of Job have a lot of trials and tribulations in there. I was about to read about some trials and tribulations that our country is going through, and I thought maybe I'd find something appropriate there. And so I just, like I said, picked at random. And I'm tending to believe that I might have been lucky. Tonight's program, before I get into the meat of it, I just want to say that our country of Belize is going through some, I wouldn't call it catastrophic, but I would say major. It's not catastrophic yet. I hope it doesn't become catastrophic. But we're going through some major haul and pulling of our governance system. What we knew our governance to be, what we hope it would have been, and now to see what it's turning out to be, unfortunately. we have our current government in power, or who sits in the power of governance under the present PUP party, who have been successful 2 terms in a row now, very successful as a matter of fact. They have been given major majorities. I would say not only just majority or super majority, but they have been given actually super majority. And apparently, the power has gotten to their head because they have been doing, especially in the last term that they just finished, before they won this second term, they've been doing a lot of crazy stuff that didn't seem like they were interested in having the people to exercise any confidence in them to give them a second term. Unfortunately, what could have been the opposition was nowhere to be seen. So these guys just ride the donkey, got themselves an easy re-election and a second term per se. No, there's nothing wrong with that when it comes to politics. That's what politics is all about. People running for elections, becoming elected, and then have the privilege to govern. What is wrong is the fact that these people who we entrust with our governance power turn around and use those very same power that we entrust to them against us, the plebiscite, the society. And they do so wantonly. They do so with no regards for our constitution, our constitutional rights, for the well-being of the country, for the judiciary of the country, for the legislature of the country, or for the like I said, the executive governance or management of the country. And it's unfortunate that they're acting in such a way that I have the tendency of classifying them as a cabal of rogue elected officials, because that's how they are conducting themselves, without a doubt. I wish it would have been otherwise, because, like I said, I don't see any justifiable reason for them to be conducting themselves in that kind of a rascal way, But they have the powers, and who is to stop them from exercising that powers, since we voluntarily gave it to them? Most people have the confidence and belief that they would have done what they promised to do initially. They did not. And as a result, we are where we are today. Most of the legislations that they had put into place have been very onerous legislations, mostly targeting the civilians of the country. We asked them to put in place UNCAC, facilitate the implementation of UNCAC, because we know for a while now we have been having a problem with kleptocrats dealing with our governance affairs. They promised they was going to put UNCAC in place or facilitate it being implemented. And so far, they are on to their second term now, and they have forgotten all about UNCAC, just like how they forgot about the referendum for for taking care of the issues that came before them in Oceania with the marijuana legislation. They go to the House and they create these laws that most of them, because most of the individuals in cabinet are legal minds and or are people who are sophisticated enough to understand what a bastardized law is. But yet they go to the House, create bastardized laws that are contrary to the Constitution, and they put these laws in the book. And because these laws are made by the privileged few for the welfare and the benefit of the privileged few, which according to them, they are the privileged few, it doesn't affect them. So they could care less who else it affects. And they don't think it's going to affect any of their children or other family members. Because according to them, by virtue of being in the political arena and controlling the powers of governance, They are exempted from any criminal conduct that they pursue or undertake, and they exculpate their family members, friends, and other loved ones as well. Those who have been following the affairs of our country know that I'm not being gratuitous in my speech or the words that I'm using. As a matter of fact, I'm a little bit more measured than I think I should be. And that's because I'm trying to deal with serious matters in a way that I don't allow myself to, become unnecessarily frustrated while trying to present this program on the airwaves and then misconduct myself, because that wouldn't be right or appropriate for me to do. But I'm a human being, and things that ail me are the things that are a travesty that is going on in my country. Nevertheless, that's just my previous for what I'm about to get into. Um, we have two major issues right now going on in the country. That is that we have an issue with these officials declaring state of emergencies repeatedly without cause or justification, or at least not as far as how the Constitution prescribes a state of emergency to be declared or be categorized. That is that states of emergency are reserved for catastrophic disasters. The idea that you have a few young people shooting at each other because of their own personal grief doesn't constitute a state of emergency, which is to say, it doesn't mean that these gangs are ganging up among themselves and trying to bring down the government of the day, duly elected, by the way, according to them. That's another question to be had, but we're not going to get into that. That's not our topic for tonight. So we don't have gangs ganging up and trying to overthrow the government by force, which the Constitution prescribes as one of the conditions for a valid and legal or proper emergency. We don't have any other country, neighboring countries trying to invade us or invading us, which is another valid and justifiable stipulation or prescript in the Constitution for declaring an emergency. We don't have any devastated hurricane right now. We don't have any major flood devastation ongoing currently. We have had floods, major floods recently, for which they had never declared any emergency, as a matter of fact, when they were justified and could have been justified to declare an emergency so they can get some funds from the consolidated revenue or funds of the country to help those people who are in that devastation. That was not done. So, as I'm saying, we have this crisis now where over 18 different instances, the government of the day, both the previous government and this current government, have bastardized our laws, our governance, misused the security systems of our country to declare state of emergency, not in the whole country, by the way, because, like I said, we don't have any such grave emergency or catastrophic emergency. We have a couple of, well, I wouldn't say a couple. We have a bunch of knuckleheads running around, shooting at each other, as I stipulated earlier, because they have their own individual problems. That is that they don't go to the court and try to solve their issues in the court. They try to solve it on the street. Unlike any other country, our country have what you call a police department, duly empowered with the powers of state to arrest and or put under remand anyone that has committed a crime or is suspected of committing a crime, in order to put them through the process of being tried, adjudicated, and finally probably either found innocent or guilty. And if guilty, sent for remand to serve whatever term or time the courts may prescribe. The problem is that the government, both past and present, have gotten into the habit of just declaring an SOE knowingly that the declaration is bogus and has no merits and does not meet, like I said, constitutional prescriptions or rules or regulations, and use those declared bogus state of emergency to commit crimes against the civilians under the color of law, under the pretext that, well, they have to declare this state of emergency because they got to deal with gangs. Well, we don't have a bigger gang than any of those gangs. Don't we have a police department? Don't we have a BDF department? Don't we have a Coast Guard department? And a small air wing, in terms of Air Force that could facilitate with planes and helicopter to help deal with the few non-scouts that are running around creating, killing each other. And then now you as the government is going to pretend that you can't arrest nobody. As a matter of fact, you go and make negotiations with some of the same people that you classify as gangs for them to turn over a gun and you let them free, or for them to turn in some drugs and then you let them free. And then you turn around and cast a wide net with a state of emergency that affects everybody living in those communities or areas where you put that state of emergency. Not to say the least that in your state of emergency, you take these people into custody. First of all, you go to their place of residence, you beat them and break up their residence and beat them up and do all kind of craziness with them, which no police officer is entitled to be judge, jury, executioner all in one. But then because of the extra powers vested in them during the course of a declared state of emergency, they can get away with committing crimes under the color of law. And they behave even worse than the gangs that they're supposed to be trying to get control of. When they go and break down people's door, break up people's house, destroy people's property in a society as poor as ours, where you have 60% poverty ridden, and you break up these people, their place, and you just walk away, take their family members into custody. You don't repair nothing. You don't follow the Constitution and let these people get to have a lawyer to look after their civil rights or basic rights or constitutional rights that is enshrined. You break the law. Who's supposed to be the lawman or the authority? You break the law and commit crimes because you so-called want to deal with criminal elements and or suppress criminal elements. You don't do that by throwing an SOE over a whole community. You do that by going in with your police powers, even if they need the support of the BDF or whoever's military support that they need in the country. Use whatever you have to do and take control of the people that are creating the mayhem. Send them up for trial. And if they are not found guilty, you let them know. So, that's required. We're in a civil democratic society, a society of law and order. And there are ways to exercise law and order in the society without having to be punitive or malignant to other people that have nothing to do with the problems. Besides that, that's only one issue. of the 13th Amendment that they're trying to create now, which is also bogus, because the so-called proposed 13th Amendment is to legalize the illegal behavior of the government. Because we've been telling them about these illegal, unconstitutional SOEs, the courts have ruled against them. So now, instead of taking the matter up to a higher court for review or for appellate reasons, hoping to maybe get a different judgment, you want to go on hard and pull the Constitution and change the laws of the country, tamper with the Constitution, and disobey the Constitution itself. You have no regards or consideration or fidelity to the Constitution. Because according to Section 2 of the Constitution, it says the Constitution is the supreme law of Belize. And if any other law is inconsistent with this Constitution, that other law is to be considered as null and void. But you go and create laws that violates the very Constitution that you're supposed to be upholding. Because you derogate people's rights in so many different ways. And then you turn around, and when the court sanctions you as a government for doing the wrong thing, you want to go and take the Constitution and amend it with a 13th Amendment, and you want to do it retroactively, as a matter of fact, so that those people whom you have committed crimes against will not have the legs to stand on to sue the government that should not be doing those criminal activities against them. So then you become a scofflaw. You become a bigger criminal than the criminal that you're supposed to be dealing with. And you're doing that all under the color of law. Before I'm going to start the regular part of the program. All of what I was going on with there just now was just a part of my frustration and preface to what is it I'm getting up to for tonight. You know, we also have the government of the day attempting to revise the Constitution in a massive way with the intent of not only just revising it, but actually eviscerating what the current Constitution appears to be, in lieu of something else that is more pliable to their ultimate objective and agenda. That is to say, that they're taking a review of the whole Constitution, lock, stock, and barrel. And some of the modifications that they're trying to make again there, they put together what they call Constitution. What was it? I think it was a Constitution Review Commission. That's what they called it initially. And then they realized, okay, well, in order to get that stuff completed the way they wanted, they needed more muscle. So then they turned around and renamed the same group or organizations that they intended to put in place, that is to go on hard and pull the Constitution. They renamed it as the People's Constitution Commission. In other words, they're going to blame the people now for being the one who, according to them, asked them to undertake this endeavor of changing the Constitution to serve their own purposes, but they're going to blame the people, while at the same time refusing to follow what the Constitution requires. That is that if the people want their Constitution changed and to allow the government to be able to tamper with any of their constitutional rights, then the government have to come to the people and propose what they want to change and cause a referendum to occur. in order for the people to be consulted, and so the people can express whether or not they're in favor of doing what the government is trying to get done. They don't want to follow the constitutional requirements. They want to just basically go to the House now. Initially, they proposed that they was going to have a referendum on these matters. They said all the right things in the beginning. And when the stuff got on the way, they proposed to educate the people about the Constitution, because 98% of the people in Belize has no knowledge, understanding, or awareness of what the Constitution comprised of. So they say, okay, they're going to have a plebiscite. But before they have the plebiscite, they're going to go out. The group of people that were members of the commission, they would go to different parts of the country, and they'll have different meetings, discuss these proposals, or solicit input from the people, and then take that input, summarize it, and take it to the Prime Minister for his review and Cabinet's review as well, and then for them to decide how they're going to dispose of the matter or deal with the matter. The bottom line is that the present government have a super majority, and they are believing that because they have that super majority, they can make just about any change that they want in the Constitution of Belize, without regards to the separation of powers doctrines, without any regards to the basic structure of the Constitution and the rights of the people, without regards to anything. That is that they want to create a constitution where at any given time, whatever comes out of the Prime Minister and the other ministers, the head becomes the law of the day. That's not a country of laws. That would then become a country, a dictatorial country where, whatever side of the bed any power broker wakes up on any given day, that's how they're going to reign. It's going to be by edicts and decrees off the bottom of the seat, out of their back pocket. We've been dealing with some of these issues as regards to the 13th Amendment. So I will not address the 13th Amendment by itself or in specifics tonight. I want to stay with the bigger picture. Recently, we've been getting some support in trying to put up some opposition to the government's dastardly conduct, and quite a few other lawyers and other individuals are stepping to the plate and developing I would say developing our resistance to the government's I would call it evil undertaking. So I would spend a little bit of my time on tonight's Friday night program for constitutional and legal matters, and I want to discuss the Constitution of Belize per se. In Section 2 of the Constitution of Belize, subsection 1 speaks about the supreme law of the country. In Section 6, subsection 1, it speaks about the equality under the law for any and everyone. Under Section 11, it speaks about the detainment and the rights of people. Under Section 16, it speaks about discrimination and the rights of the individual to not be discriminated against. Under Section 18, it talks about public emergency and what constitutes validly the process and or the issues that should be able to trigger a viable and a true state of emergency, not bogus declaration just for, just because they can declare. And under Section 19, also for personal safety and uh, people's well-being. And then under Section 20, for judicial review, which is the purview of the court and not the legislator, nor the administrative section of government, as well as under Section 95, which gives the powers of the, I would say 94 and 95, which gives the power to the judiciary, unlimited jurisdiction to deal with all matters legal and constitutional in regards to our country. And it's not because these people don't know about what I'm speaking to or making reference to. Most of them are senior lawyers who are advising the government. And the Attorney General was recently promoted to become a senior counsel himself. So I'm not making reference to or talking about people who are wet behind their ears, who doesn't know what's right and what's wrong. But they join the cabal and serve the interests of they who can drop them a few crumbs off the table, and to hell with the people and the public. And that's unfortunate and unreasonable. Okay. I'm going to start with tonight's program dealing, I'm going to make reference to the particular, I have a case here that was heard in the Supreme Court of Belize, AD 2012. The number of the claim was 597 of 2011. So those who remember that date will recognize that to have been under the previous administration when this particular case was heard and dealt with. One of the claimants was the British Caribbean Bank Limited, and the first defendant in this particular case was the Attorney General of Belize, and the second defendant was the Minister of Public Utilities. I'm citing this case and reading from it or using it as a part of my program for tonight because there's a critical part that I want people to grasp. And this case lends itself to clarifying that point. And I'm going to state it as a matter of fact before I go further. That is that the legislature of Belize, according to our constitution, the current one that we have, because you only could have one constitution at a time, the current constitution that we have, according to that constitution, it says that the legislature is empowered to make and amend laws or to amend the constitution. But they are not empowered to amend the constitution to the point of dispensing with the existing constitution and or parts of it, especially certain parts. There are certain parts that they're entitled to, for administrative purposes, amend for the proper governance of the country. But when it comes to the separation of powers, the legislator is prohibited and barred from having anything to do with violating the separation of powers. That is that The legislator can't wake up one day and decide, okay, well, you know what? We're going to abolish the judiciary. We don't want no judges anymore in our country. We don't want any issues to be dealt with by any judge. And we don't want to be told by any judge that the legislature, I mean, the legislator or legislative actions that we take are inconsistent with the Constitution, and therefore they are to be ruled as unconstitutional and null and void. We don't want to hear that. So we're going to just, as a matter of fact, abolish the whole judiciary. That's it. The legislator don't have that power to do that, to tamper with the separation of powers, because the judiciary is an equal branch of government. It's as equal as the legislature, and it's as equal as the administrative. So for all intents and purposes, I hope people understood what I said there just now. Anyhow, we'll deal with some of those as we go on through the program, okay? That was just a previous to some of what's coming behind. And it's going to come out, as I said, why I'm using this particular case that was ruled upon. And why I'm using it too is because it's not just a case that was ruled upon at the Supreme Court alone. This particular case went to all three levels of our judicial, well, I would say there are 4 levels of our judicial system, okay? There's the Supreme Court, there's the magistrate court below the Supreme Court, there's the local Belize appellate court, and above that local Belize appellate court, there's a regional jurisdiction of final resort, which is the highest appellate court under the jurisdiction of the Caribbean Court of Justice. Okay, so I hope those of you who don't know law or much about the legal process in our system of law and legality understood what I said there just now, that we have the magistrate court that you deal with, simple, basic issues, and then you have the Supreme Court that deals with higher criminal issues, and then you have, if you go and you lose a case at the Supreme Court and you still feel aggrieved, you have a chance to appeal that Supreme Court judgment against you at the local Belize appellate court level. And in most instances, when the government go and lose cases at that level, because they have a deep pocket, which is the public purse or the public treasury, they and other rich people who can afford it, when they lose their cases, they can go to the ultimate jurisdiction, which is the Caribbean Court of Justice. Some people may remember that we used to have what they call the British Privy Council as our last level of court, but that has been changed to the Caribbean Court of Justice. So don't forget, as I just mentioned to you just now, this is not just only a presentation for the purpose of trying to flesh out these constitutional matters. It's also a teaching moment. So I hope that you remember that you have 4 different levels of courts as part of our judicial system in Belize. And I just made reference just now to a particular case that we're going to be using as our understudy for tonight. I hope I don't run out of time. I don't see any of my other colleagues yet. And so I'm just going to continue the journey. So just now I mentioned to you the claim number was 597 of 2011, and it was between the British Caribbean Bank Limited as a claimant who brought the claim, and against the Attorney General of Belize as first defendant and the Minister of Public Utilities as second defendant. Then they also had another claim that was joined together with this previous one that I mentioned just now, involving some of the same people, right? I mean, basically. Claims number 646 of 2011 that stemmed out of the same issues and problems. The claimant in that particular filed case was Dean Boyce as the trustee of the Belize of the BTL Employees Trust. Okay, and the defendant in that case was the Attorney General of Belize, as I previously stated in the previous case as well, and the Ministry of Public Utility, which was also part of the other case that I made reference to just now. So you had two cases that was combined for hearing on this particular instance. The hearings were done in 2012, 13th of March, 14th of March, and 11th of June. Mr. Emon Courtney, Senior Counsel, and Mr. Shanti Arthurs Marine appeared. Oh, man. Okay, just a minute. I touched the surface of my device and it sent the information running all over the place. Okay, I got it back. Okay, as I just stipulated, Mr. Emon Courtney, Senior Counsel, and Ms. Ashanti Arthurs Marine appeared for the claimants in claim number 597, which was the first one that I made reference to, of 2011. And Lord Peter Goldsmith, Queen's Counsel, and Mrs. Magali Marine Young appeared for the claimants in claims number 646 of 2011. Mr. Dennis Barrow, Senior Counsel, and Mr. Nigel Hawk and Ms. Ileana Swift appeared for the defendant in both claims. The judge of record in this particular instance was Justice Legal. The way these cases are set up when there's a ruling, there is what you call initially as the first part of the writing, the presentation for the decision purpose, is stipulated as being the judgment. And in the judgment, there are what you call preliminary facts, finding facts, and final facts, as per what the judgment stipulates in terms of what the judge arrived at after hearing the whole case and making his final determination. This particular case, I think, had like 81 pages. And there's no way that we will cover 81 pages in tonight's presentation. So I'll do the best I can for tonight. And some of it, well, of course, I won't be able to cover all the 81 pages, even in the final presentation that I will make at the end of the day, because there's too many other things going on. And like I said, we have this Constitutional Review Commission or People's Constitution Commission that we've been dealing with in terms of what they're recommending and trying to compare that to our current constitution to see how onerous or dastardly their intended effort will be, so that when they come to you as the people with their shenanigans, at least you'll have a little heads up. But that's not for tonight's program. We have that in the background that we've been working on for quite a few weeks, and it's going to take us quite a few more weeks, probably another couple of months, to go through the whole package and flesh it out. But for tonight, I specifically want to deal with this particular case that I'm presenting to you. And I'm doing it like this for good reason. So like to ask those of you who listen to our program while it is live, like in tonight's case, and or those who listen to it after the fact at your own convenience, sometimes on weekend or maybe overnight or whatever, please be patient with me. Indulge me with what I'm trying to get done here. And I promise you, I sincerely promise you, that you'll be much better, or you will be the better off for having done so. I know your time is valuable, but I'm promising you, some of you who are liars, those of you who are not liars, who might have an interest in this matter for whatever your reasons, be patient. I'm telling you, I'm not making this effort just because I have a imperial lip on my face or because I want to come and stand on this program. Because I'm the person that runs the program, so I could go and stand on it all day long, every day, as many hours as I want, in terms of my scheduling. But that's not what it's about. This is about getting yourself prepared for what's coming at you. What's coming at you is the 13th Amendment already in process. And what is also in process is the PCC recommendations. Whether you like it or not, it's going to go through its process. And whoever gets hurt by it, that's just the way how it's going to be. Only you, the people, can save the people. All I'm trying to do is facilitating you, the people, with a little bit more opportunity to be a little bit more appraised of what is it that's coming and how you might be able to make a difference in terms of looking after your own well-being. Because you have a government in place that has no concern, interest, or desire to do what's right by you. Otherwise, I wouldn't be here wasting, well, I shouldn't call it wasting my time, but investing my time, I would say. As I said earlier, we're happy that a lot of other people are getting involved. And that gives me a little opportunity now to be able to go back to dealing with some of the more substantive stuff, rather than just beating on the 13th Amendment alone, which is the talk of the day. I want to make sure that we don't lose focus on the whole bigger picture of the whole Constitution that is being revised and recommended for major changes of our whole governance system, including getting rid of the head of state, getting rid of the governor general, empowering the police state, the police officers and the different departments to be more aggressive towards the civilians. A whole lot of craziness coming down the pipe. In fact, we're dealing with some of it right now. It's not just coming down the pipe. We're dealing with some of it right now. But if we think that what we're dealing with is the worst of the worst, you better wake up. So please, I'm begging your indulgence for your time spared. I don't know how else to justify making the request that I'm making, okay? I don't just plainly say, I think you'll be better off if you take the time, the effort, listen to what I have to say. You don't have to take what I say as no gospel or the Bible or the final word or nothing. You're entitled to have your own ideas, opinions, conclusions, and expose whatever is it that you conclude on as the basis of your own belief or hopes. But without the information, you're a lot worse off, and you'll be much easily bamboozled by these jackals that we have running our affairs. Okay? So please, again, for the last time, well, not necessarily for the last time, but again, I'm asking you, be patient with me. I'm going to be babbling in your ears. I'm going to be making mistakes as I go through this stuff. It's a lot of reading, a lot of work. Like I said, 81 pages. I got to be able to make the presentation the most lucid way I can. Okay? And I'm telling you up front, I'm going to be making mistakes, or maybe babbling in your ear, and maybe saying some things 1 or 2 or 3 times over, or maybe I'm going to be missing pages and skip pages, I can't give the whole 81 pages. And I'm promising that next week, Friday again, we'll continue with some more of it because I can't do all of it tonight. But let's move on. So as regards to the preliminary facts, like I said, under the title of the judgment from the judge himself, Judge Leal, he said he goes on to say on the first item that he listed, he says, item number 1. On the 25th of August of 2009, he said, the legislature of Belize, let me see, I think I want to increase this stuff a little bit more. Just make sure I have, because I'm going to want to try and read it as fast as possible, knowing that I'm under pressure with timing, okay? And every once in a while, I know the possibility exists that I'm using an electronic device that I have to use to up and down and go across and whatever it's not. And every once in a while, I touch the screen and it activates and it goes in a haywire or goes differently on what I'm trying to get done. And then I got to go back and recover the information. So we're going to go through a process of, like just like if we have on baby here, okay? This can be for we baby. So I have trials and tribulations. Just bear with me. The item number 1, the judge went on to stipulate as being one of the facts, because we're dealing with the facts, right, as they were presented to the judge. On the 25th of August of 2009, the legislature of Belize enacted a Belize Telecommunication Amendment Act number 2009, number 9 of 2009. The 2009 Act was like the short title for this particular issue. It says, that particular act, which amended the Belize Telecommunication Act of 2002, number 16 of 2002, which was originally the principal act, by adding and inserting new sections number 63 all the way through 74. Immediately after section 62, that is, they went from section 62 and they added on 63, 64, 65, all the way through 74. Immediately after the original last item that existed at that time of the principal act. It says the new section 63(1) in the principal act is as follows. Now, before I do that, before I read that part, I'm going to explain to you what's going to come, because I know the case. I've spoken on the case. As a matter of fact, I used this case, I think it was in the beginning of this, when we set off this platform, 221 shows ago, somewhere between the first 5 shows, we made this presentation. We did not complete it then because we went on to other things, right? We had to stay with the issues of the day or the projected emergency situations that we were dealing with. A lot of stuff came up and go. But why I'm coming with this stuff is because I'm trying to use this case to validate, to point out, not in my words, I'm the one probably giving the words to what's written down and making the presentation. But what I'm trying to do is to let people know that some of these trials and tribulations that we're going through right now, that's going to get worse, has been dealt with in the past. They have been ruled upon in the past. Some of the criminal conduct that our present government is carrying on with have been dealt with in the past. But they're coming along now as scofflaws and pretending that either they don't know about these laws, or they just don't want to obey them or do nothing about them, or they want just to ignore them. And I don't want to be the one to come up here on this show and just speak off the top of my head and tell or say things. I'm trying to use, like I said, the case itself as a means to convey the important message or information. Because at the end of this process, what I want people to understand is that the government have no powers constitutionally or lawfully to violate the Constitution itself or to derogate or violate people's constitutional rights that are enshrined in the Constitution. But I want the documents to speak to it or guide us as we go through this process. And at the end of this process, you will find out that what I've been saying all the while along for this last 21 shows was correct. We didn't just wake up one day and pull the stuff out of our back pocket and decide to just get my live programs and just banter around and just stipulate, what we wanted to because we wanted to come off and sound smart. No, that's not what it's about. We have a hell of a situation that's been faced recently by some of our people. It's being faced right now, and it's going to get a hell of a lot worse that we're going to have to face in the near future. And that's what my agenda is all about and my reason for indulging in this process. I could have been sitting back watching TV right now, or maybe, eating something or drinking something or just whatever, or maybe just step on TikTok or some other place, This is more important to me, which is why I indulge in this process. Section 63.1 reads as follows. When the license granted to a public utility provider is revoked by the Public Utility Commission, or where a license ceases operation, licensee, the owner of the license, ceases operations on his own right, or loses control of operations, or where the minister considers the control over telecommunications should be acquired for a public purpose, the minister may, with the approval of the Minister of Finance, by order published in a gazette, may acquire for and on behalf of the government, meaning the people of Belize per se, all such property as he, the minister, may from time to time consider necessary to take possession of and to assume control over, in this case, telecommunications. And every such order shall be prima facie evidence that the property to which it relates is required for a public purpose. That is what was stipulated in the statutory instrument, okay? Now, let me say something to you here quickly, Belizeans at home and abroad. I hope that many of you would understand or remember what we have said on this show before, which we were just repeating the obvious or what should have been obvious, or at least to the legal trained mind should be obvious, that a statutory instrument that a minister writes for management purposes of his department does not trump the Constitution. Can anybody, I was going to be funny when I was going to say, can anybody repeat that for me and explain to me what is it that they understood from what I said just now, because it's critically important to understand that. So I'll repeat what I just said in a different way, with more emphasis and with additional words in my commentary, right? The Constitution cannot be override or overridden by a statutory instrument. Any statutory instrument that is written for it to be legal or constitutional, for it to have the power of legality behind it, which is what the Constitution does for any legal document that the government produces, that statutory instrument has to have the validity and the backing of the Constitution. In other words, it has to fulfill the prescripts of the Constitution. It cannot be violative of the Constitution. It cannot be made with an intent to abrogate the Constitution, or it cannot be made outside of the bounds of the Constitution. Why? If it's done outside the bounds of the Constitution, Section 2 of our Constitution says any other law, right? And when it refers to other law, as you always hear me emphasize, it means laws that the legislator makes. If the legislator makes any law, any other law, laws that are other than the Constitution itself, those laws, in order for it to carry the force of legality and lawfulness, must meet the prescripts of the Constitution of Belize. Otherwise, they are null and void. So the legislature can make a million different laws, but if that million law does not comply to the prescripts of the Constitution, then those other laws are unconstitutional, unlawful, illegal, null, and void. Okay, so part of this particular, and why I brought that up, right? Because part of this particular essay here that I just read, the court in its final judgment at the Supreme Court, at the appellate court, and at because this matter is considered to be a stare decisis matter or a settled law. Settled law are laws that goes through all the different levels of the court at its highest possible level and are ruled upon with a finality. Okay? That's what a settled law is. In other words, it's a guide for all the judges to follow and to rule according to those settled law. This particular case became a settled law. It went to all three higher levels of our court. It didn't go to the lowest level, the magistrate court, because it wasn't a magistrate issue. It was a Supreme Court issue. Remember what I just mentioned to you earlier? Our Belizean judicial system have 4 levels of court. Okay? But I want to repeat that again for right now because, we'll have to talk about that again at some other point. But I was just emphasizing as regards to this particular essay that the minister made. Okay? And even if all 100% of the legislator gets together and make a particular law that they would like to see come into existence, if it's not made within the bounds of the Constitution, it is still outside the bounds of the Constitution. If it's unlawful, it's unlawful. If it's illegal, it's illegal. If it's unconstitutional and doesn't meet the constitutional prescripts, it is unconstitutional. And if it falls into those categories of unlawful, unconstitutional, then it's null and void. So they got to go back and redo it. They either got to amend it to make it correct, or they got to do another one. That's what's required. That's the way the system is supposed to operate. Mind you, it doesn't always happen like that. Because last, Wednesday night and Monday night, those of you who follow our program will recall that we spoke to those matters. And we pointed out where there were some laws that were made by the legislature that was turned down because they were not judiciously. The legislator can't pronounce what is right, what is legal, and what is illegal. That's the purview of the court. So let's move on because, like I said, my time is running. Oh man, I won't be able to do the justice I wanted for tonight, so I might have to skip a lot of extra stuff. Okay, so it goes on to say here, as part of the record for the The minister responsible for telecommunication in that case, acting under just a second, this stuff is a bit too okay. I think that's good enough now. Otherwise, I'm going to have to be going back and forward, side. Okay. The minister responsible for telecommunication in this particular case, acting under the inserted section 63(1) above, issued two statutory instruments. Statutory instrument number 104 of 2009, for the Belize telecommunication assumption of control over Belize Telemedia Limited, order number 2009, and also number 130 of 2009, which amended number, just a second, too much, okay, which amended number 104 of 2009, entitled the Belize Telecommunication Assumption of Control over BTL Limited, and order number 2009, made on the 4th of December of 2009, order number 104 of 2009, stated, among other things, as follows. It stated, and whereas after careful consideration of all the facts and circumstances, I, the person being the minister at the time making the particular order or a statutory instrument, said, I consider that control over telecommunications should be accrued for a public purpose, namely the stabilization and improvement of the telecommunication industry and the provisions of reliable telecommunication services to the public at affordable prices in a harmonious and non-contentious environment. Now, he said, therefore, in pursuance of the above objectives, it is hereby ordered as follows, and ordered by him. And then there's one item number 1, which follows by for that, which means that it's not spelled out. And item number 2, which is spelled out, reads as follows. The property specified in the schedule to this order is hereby acquired for and on behalf of the government of Belize for the public purpose of aforesaid. Now, this was, like I said, the case was between Telemeda and the bank and the government. But I want to go to the parts that are of interest to us. Okay. The intention of the legislation was to compulsory acquire the properties, rights, and interests held by the claimant in both claims. I want to skip part of that and go to, okay, it says, the claimant in the above claim filed appeals against the said this decision. That is, that the decision was made and the claimant at the time was not satisfied with that decision, and therefore they decided to appeal. Let me see. Okay. Yeah, that should do. Great. Okay, so the claimants in the above claims filed appeals against the said decision from the Supreme Court to the Courts of Appeal, namely Civil Appeal number 30 and 31 of 2010, within less than a year. In other words, they had their appeal, they had their appeal granted to them. The Court of Appeal, Morrison J.A., that is Justice A. Morrison, Justice Alenyi, and Justice Curry. In a written decision, the justice delivered on the 24th of June of 2011, 1 year after, allowed the appeals and declared that the Acquisition Act and order were inconsistent with the Constitution and were unlawful, null, and void. So you see where I was mentioning earlier that there are instances when the minister, in this case, used the power of governance authorized to him to create an SI, to go and dispossess somebody of their private property, which is also illegal, by the way. But they wanted to couch it under what you call eminent domain for public purpose, which would justify the government then being able to go into the government treasury, take the person's property, and pay for it. But in this case, they were having a hard time paying the people for their property, and so the case got appealed. Okay. So the matter was taken. It says the Acquisition Act referred to was the 2009 Act, and the order was order number 104 and 130 of 2009 that was referred to above. By this declaration, the Court of Appeal held that the acquisition for the properties, rights, and interests of the claimants in claim number 874 and 1018 of 2010 was unlawful, null, and void, despite the fact that it was done under a statutory instrument by the minister at the time, which is to say, like I told you before, a statutory instrument, if it's illegal and unlawful, it cannot trump the Constitution. And therefore, the judge, the 3-panel judge at the appellate level, agreed that the minister acted unlawful, and therefore his effort amounted to a bastardized effort against, contrary to the Constitution, and was ruled as according to what the Constitution prescribes or demands in Section 2, it was ruled as null and void. That's what the Constitution said they should have done, and that's what they did. Why? Because the knucklehead minister feel like they could power play and just write up any kind of bogus stuff, and whatever is it that they write up must be considered legal and lawful. You know, they try to power play on a situation and they got themselves smacked down, basically. Anyhow, I'll proceed a little further. I'll read number 4, item number 4 in the presentation to the judge, or that the judge had to deal with. It says the Court of Appeal also held that on the evidence and for reasons given in the judgment, which is part of what I'm reading right now, the appellate court did not think that the compulsory acquisition were made, were duly carried out for the stated purpose or public purposes. That is, they saw through what was being said incorrectly by the minister in his statutory instrument, and therefore they ruled according to law rather than according to the high-powered effort of the minister who was just trying to couch himself or hide himself under the cover of law. No, it says it goes on to say, see page 89 of this judgment. So this particular judgment is more than, I was saying, it one page, but I think it's more than that. I recall one was one page, which might have been a different case. In this particular instance, the Court of Appeal also concluded that the 2009 Act that was contrary to Section 17(1) of the Constitution, because that Act that the legislator had revised did not prescribe the principles on which reasonable compensation was to be paid within a reasonable time. The court also ruled that the 2009 Act that was revised did not secure to a person claiming an interest in the acquired properties a right of access to the court to establish that interest, and also did not secure to a person who had been awarded compensation by the court a right of access to the court to enforce his right to compensation. That is, that the person was left lingering out there and the government did not dutifully follow quickly and settled, nor did they provide for any quick settlement. So it goes on to say, see page 63 and 64 of the judgment. It says, in relation to whether the 2009 Act was proportionate or was for an illegal purpose, the Court of Appeals concluded that the compulsory acquisition were not a proportionate response to the reacquisition, to the requirement of the stated public purpose, and held that in carrying out the compulsory acquisition, the government acted for an illegal purpose and thus breached the appellate constitutional, no, the appellant, meaning the person that had brought the case for additional judicial review, had breached the appellant constitutional rights to protection from arbitrary deprivation of their property. And this is the same case as in this, where this Amendment 13 is trying to go. That is, they're trying to create a situation where they're going to pretend that they are amending the Constitution while breaking the Constitution at the same time. That's a bastardization of the Constitution. You cannot make a law that is contrary to what the Constitution says is legal, lawful, or constitutional. But that's what these, I was about to say something wrong. That's what these scofflaws are doing. They go ahead and make these laws, they go through the motions. Sometimes they read these things 3 times in one sitting, hurry it up, put it on the book. It's illegal. People get hurt by it, but if people don't have money to fight them, they get away. But when they meet like Boeing and they meet like Ashcroft, or they meet like Zabanese, or any of these big power players or money people in the country that fight them back, sometimes they don't even put up the fight. They go and settle with them and pay them more than what they're supposed to be paying them in the first place, just to shut up and silence the stuff. In fact, as a matter of fact, they go and give them more money because that's part of how they get kickback for campaigning when they're ready to go do their political campaigning. But anyhow, I want to read a little further along Item number 5 goes on to, let me see where I'm at. I gotta watch my timing. Oh man. You know what? I'm gonna have to skip a lot of these things here right now. Let me go further. I want to skip a lot of these because we could always come back to those. But there are some salient points that I need to touch as a part of tonight's presentation, because I don't want to leave. Okay, so it goes on to say here under item number 10, it says, Section 3 of the 8th Amendment purported to amend sections, oh man, by Charles, I messed up. I told you, I knew it was going to happen. Oh man. I just touched the thing slightly and just gone crazy upon me. Anyhow, I gotta be a patient. I have to be as patient as I'm asking you to be with me, because if I get impatient, then I mean no sense asking you guys to be patient with me. Oh man. Okay, yeah, I got it back. Okay, so Section 10 says, under Section 3 of the 8th Amendment, which purported to amend Section 69 of the Constitution as follows. Number 3, Section 9 of the Constitution is hereby amended by the addition of the following new subsection after subsection 8 to add subsection 9 for the removal of doubts. It is hereby declared that the provisions of this section are all inclusive and exhaustive, and there is no other limitation, whether substantive or procedural, on the power of the National Assembly to alter this Constitution. Basically, that part did not exist in the Constitution before, and it was intended as a power grab. That is to say, the Constitution holds at bar the government from doing or transgressing certain things, and or it holds or forbids the legislator from making certain legislation, especially outside of the bounds of the law. Okay? And now, Mr. Barrow, in 2011, we just read this stuff last Wednesday, Wednesday program when we were having that debate again about this Amendment 13. And Mr. Barrow wanted to make a power grab. That is that he wanted his legislator at the time to have a super power that would be supreme and above the supreme law of the land. That's how onerous these people are. That's the kind of mindset that they have. Okay? So the man not only wanted to do it, he actually ended up doing it. That is that he went to the House, he passed what was a bogus amendment because it wasn't legal, and he wrote it into the Constitution. The court told him to take it out. Well, the court can't go and take it out itself. That's why I didn't tell him to take it out. He refused to take it out, to the point that he left office, and Mr. Belizean now come on, try and make use of this same craziness here. Instead of him clean it up and take it out as per the court's instruction, because it was ruled null and void and unconstitutional. Mr. Belizean is currently trying to use it now to say, well, if it's in the Constitution, he can try and make use of it. So he's now trying to say that for all intents and purposes, he have a super legislator. The fact that he have a super majority means that he have what you call a super legislator that is supreme above the supreme law. And that's what how these jackals operate. And that's why I said I wanted us to read that and some other little pieces that I'm going to try and read before my time is up. It's getting close to it. But just to show you how scofflaw these people are, how onerous they are. And then they turn around and want to use these very things against the public. They don't use these laws against themselves, These laws are designed specifically to hurt members of the public. Why do they have to do that? What joy do they get out of doing any kind of craziness there? Abusing the powers that we vested in them to look after our affairs. I'll proceed to read another portion here. I think this was... Okay, I want to read what the judge was intimating at this particular point. He says, guys, remember, I'm reading part of the judgment that was handed down, okay? The judge went on to say, this section seeks to limit the powers of the National Assembly to alter the Constitution to the provision of Section 69. According to the amendment, there is no limitations in the Constitution other than Section 69 on the National Assembly, which is bogus, because that's not what the Constitution had said before or implied or was intending. To alter or amend the Constitution. It seems that the intention is to prevent constitutional principles such as the basic structure doctrine of the Constitution. That is to say, by him writing up that little piece of legislation and put it into the Constitution, two specific sections. This one here under 69.9 that never existed before, and the one under Section 2.1 that they added Section 2.2 to say that the legislator was all supreme, right? And that any law that the legislator made would not be considered to be in violation of the existing Constitution. How the hell did they arrive at that? Who gave them that kind of power or authority to trump the Constitution? And to say that the gentleman was a senior counsel, high status in the legal community, okay? Beyond being high status in the legal community, the man was the prime minister of the country. And have to find himself acting so dastardly, violating the very Constitution that he swore fidelity to. I'll proceed to read another section here. I think it was... oh, no, I never finished that one. That one wasn't completed. I'll say. And then it went on to say, a doctrine examined below and Section 68 from providing a limit on the power of the National Assembly to alter or amend the Constitution. Section 68 states that subject to the provisions of this Constitution, the National Assembly may make laws. Remember, I mentioned that earlier to you when I said that the legislator is empowered to make laws and to amend laws, but those laws have to fall within constitutional prescripts or within the bounds of the Constitution. They can't go outside of the bounds of the Constitution and just create just about any kind of crazy laws that they want to imagine or wake up one morning and decide they want to do. That's not what it's intended to be. The powers of the legislator are to work within legality and the structures of the Constitution, and not to be violative of the Constitution, not to go and make bogus laws that violate the Constitution and try to pretend that, okay, because they make bogus laws and put it into the Constitution, that then that bogus law trump the original intents of the Constitution. That's a bastardization of the process. And they get away with it a lot, because most people, like I said earlier, don't know the Constitution, have not dealt with the Constitution, and therefore are not in a position to be able to, tell these guys where to go jump. In fact, we had members of the public that sued the government recently to force them to comply with the Constitution and the stupid compromised judges that they have rule in favor of the government to make the government continue break or violate the Constitution and bastardize the law, which is inconsistent with the Constitution as well. Because the Constitution empowered the judges as a separate, equal branch of government to keep the government checked in terms of following the law. But these guys come as on contract to serve in the country, and they don't want to get into no kind of issues with the government. So they rule unconstitutionally to let the government continue violating the Constitution so that they don't have to worry about their contract. And if they want to carry me in a court, or the judge want to judge me himself in contempt of his court orders or rulings, then let him do. Because I could tell him the same thing I'm telling you, the general public. According to law, is how he was supposed to rule. And failing to do so puts himself in a position where I am not impugning him. I'm not libeling him. I'm just repeating what happened. And what happened was dastardly, unconstitutional, and a travesty. As a matter of fact, he shouldn't be sitting on our bench anymore anyhow, after being caught, in his own words, on live mic, lying about a particular case that he was sitting on. That alone should cause him to have been vanished from our legal community. Okay? So don't make them bring them kind of craziness to me and think that none of us out here understand and know what the process is and how it's supposed to be done and could judge them. They could judge you when we go as a criminal in front of them. But we could judge them too when we see the dastardly conduct that they carry on. We are entitled, according to the Constitution, to our opinions, our ideas, our perspective, and we have the right of speech to be able to articulate to whomever we want to articulate whatever is it that we see or form a part of our observation. Especially if it's a commodity or an issue or a matter that is of public concern. But anyhow, I'm getting at the point where I'm already 2 minutes beyond my limitation. There's a lot more that I really would have liked to have covered in tonight's program. Unfortunately, I have not. I'll just take another stab at maybe another 10 minutes of this process, and I hope that you indulge me with being able to go ahead and do that, because we are going to be speaking on other programs, let's say, for example, like Monday and maybe Wednesday of next week, on this 13th Amendment and other issues. And now that we have all the legal, well, not all, but a lot of the legal community stepping up to the plate and expressing their concerns, if we want to be able to join them or to have them join us, because basically that's what's happening now. They are joining us. We have been on this path for 2.5, almost 3 years now, anticipating this constitutional review process. And I just hope that over that period of time, 321 different programs that we have had, that you have derived some public benefit and are in a much better position right now to understand and know and relate to, as well as defend your rights and your Constitution. And don't allow yourself to be hoodwinked or bamboozled for these guys to take away your power and turn around and blame you for what they do to you. I'll go to item number 11 and just read a little part of that. It reads as follows. As the appellants were successful in the Court of Appeal, they believe that the orders made by that court entitled them to possession of the properties that was the subject of the void 2009 Act. Remember now, the government went to the House and they made an act in 2009, and the court declared it null and void, right? Which is what we're talking about here right now. And the order also, The other was actually the statutory instrument that they tried to piggyback on top of that constitution modification, right? That was void. So once the constitutional modification was declared void, the act that was contingent on that modification was also, for all intents and purposes, a stillbirth or dead before it was even conceived. That not being accomplished, they applied to the Court of Appeal to intervene and grant consequential relief, which would have satisfactorily given them possession of the properties. But the Court of Appeal declined the application. The applicants who had already filed the claim in this matter got leave from the Court of Appeal to the Caribbean Court of Justice. Remember I told you that this matter went all the way to the Caribbean Court of Justice? We're now reading it here in black and white, right? So I wasn't talking off the top of my head. I had already reviewed the presentation, the program, and the case. And like I said, these are one of the first cases that we brought up and dealt with when we first started on this journey. So I wasn't wet in the back of my ears and didn't know what I was supposed to be talking about. I knew exactly what I was talking about, which is why I was able to make the previous presentation the way I did. Okay, so the appellants who had already filed the claims in this particular matter had got leave from the Court of Appeal in Belize to the Caribbean Court of Justice on the question of whether the Court of Appeal's decision not to grant them consequential relief as well, which they had requested, whether or not that was correct, and whether the Court of Appeals was wrong on the discrimination ruling above, because they had also claimed discrimination, especially in the part of the case. Remember, there's two cases that was joined up, right? In the discrimination part of the case was the part with Mr. Boyce, right, on behalf of the employee trust, and whether the Court of Appeal was wrong on the discrimination ruling above. When that appeal court came before the CCJ, the claimants in the present claims wanted to argue before the court as part of their appeal. Now, remember, let me say something just as a passing by, right? That is very instructive for people to be aware of. When you have a case being heard at the Supreme Court, the evidence that is provided at the Supreme Court, depending on what the judge decides to accept as evidence, right? That will be the basis on which, if you lose your case, you will have to go and appeal. So if the judge at the Supreme Court level doesn't accept all the evidence that your lawyer try to present on your behalf, it means that you can't go at the appeals level then when you file an appeal, because they didn't grant you, you still feel aggrieved and you didn't win the case, but you want to appeal. You cannot go to the appellate level then and try to argue the whole case all over again and try to bring in different parts of the case that the previous judge didn't allow in. Okay, so sometimes judges can stifle your case too before you even get to the appeals level, because the appellate level will not hear the whole case, or they will not allow you to bring in parts of the case that was not allowed by the previous judge. The only thing that the appeals is on the basis of what was accepted or submitted and accepted by the judge in the first case. And the same thing goes, whatever you discuss at the appellate level is what you're going to have to discuss again at the Caribbean Court of Justice. They will not open up the whole of your case all over again and give you a new trial altogether. In other words, you're not getting a second, a third, or fourth bite at the apple. All they're doing is going through the technical review process of reviewing the evidence and to see whether or not the judge below them made a mistake, oversighted something, or sometimes you could claim that maybe they not only oversighted, but they deliberately threw your case. right? But that's a very hard road to hoe. Nevertheless, I want to. I said I was going to take. Yeah, I think I'm there already. Okay, so I'm gonna have to just say a few more statements here with this because we are at the ICJ process right now, right? And in this case, uh, says when that appeal came before the ICJ, the claimants the claimant presenting the claim wanted to argue before the court of appeal at the CCJ as part of their appeal the issues raised in the claims originally. That is to say, the validity of the 2011 Act and order that subsequently came out of that as a statutory instrument, and the Eighth Amendment itself. The CCJ, the Caribbean Court of Justice, majority, Justice Anderson and Justice, the court majority, which included um, in bracket, it says in bracket here, Justice Anderson dissenting. Okay, there was three judges on the case, and Justice Anderson was the only dissent, and the other two judges are majority. Then that's what is stipulating here. The majority held that since the 2011 Act and order and the Eighth Amendment could have a devastating impact on the appeals, the CCJ considered that the better course is indeed to stay the appeals pending the outcome of the challenge in the normal manner of the 2011 legislation. Then it says, see Dean Boyce versus, Attorney General, and the rest of the case that is cited there and being referred to. So the claims reverted to the Supreme Court with the present claims. And then the present claims, it says the present claims is what I was going to go into, but I'm out of time. I'd just like to say thank you, Belizeans at home and abroad, for allowing me to make this presentation and using up your valuable time to listen to it. I hope you have an opportunity to go back, listen to it over again at your more relaxed time, and be able to dissect some of what I was saying, probably get a clearer understanding if you review it and go over it again. And we don't expect that without legal training, you should be able to understand the back and forward and the intricacies of how these cases are presented or done. But the essence of the fact that I was trying to bring to your attention tonight, and probably will do so again, like I said, probably next Friday, Constitutional Night. I'm hoping to bring some more of this matter because I want you to hear it from the judge's perspective rather than just from our perspective, which is to say, if we disagree with something, that doesn't mean that we carry the weight of justice on our shoulder in terms of being able to make it right. We can just argue about it, we can discuss it, we can stipulate on it, but at the end of the day, it is the judges that make these rulings, and decide even what the legislator do, whether it is right or wrong, whether it is legal or illegal. And before I close off my program for tonight, I'm going to leave what I was doing earlier. That's the end of that. But I want to just make a stipulation, and that is that in the present recommendations that the PCC is making to the government, is saying that the Prime Minister will now, under the new constitution, if they get it revised the way they want it, the recommendation is that the Prime Minister will become the head of state, will need no Governor General, and the Prime Minister will appoint 5 individuals who will become the guardians of a constitution, that is to say, a constitution commission. And any of these legal and technical and constitutional matters will not then percolate in the court anymore, because the court will be stripped of that jurisdiction under Section 20 and Section 95 of unlimited jurisdiction to hear cases and rule according to law. 5 of the Prime Minister friends or relatives will sit as a commission appointed by him to make sure that constitutional matters are ruled according to how the government legislate them, for all intents and purposes. Not as of right now, where the judge is telling the government where they are legislating wrong, or telling the government where they are managing wrong. Because the current judiciary is an independent, an equal and independent branch of our government, who is tasked with the responsibility to keep our government and our legislators in check, as well as the general public, by the way. The dog want to eat with supper, that if we get a chance to have any supper, the dog want to eat it before we get to eat it. Because we will be handcuffed by the new constitution to the point where our freedoms or inalienable rights, or civil rights, or natural rights, or constitutionally enshrined rights will all disappear under the present proposals that these people are contemplated. Of course, I've gone far beyond my time of presentation by 16 minutes. And so I just want to say to you, thanks again, and for giving me the privilege to babble in your ears and to try and say what I've been trying to say. And hopefully you, the general public, would have derived some positive public benefit from what I was articulating. Of course, we have a lot more to go, a lot more explanation to do, a lot more situations to bring to your attention. But for tonight, I'd just like to say thank you very much for your time and attention, and God bless Belize and Belizeans at home and abroad and the rest of humanity. Good night. Bye-bye.